Now, while Justice Thomas did agree with the opinion of the court, he wanted more. The court today correctly decided that Mexico has not plausibly pleaded that the suit falls under the predicate exception of the Protection of Lawful Commerce in Arms Act. I write separately to note that the court's opinion does not resolve what a plaintiff must show to establish the defendants committed a violation. It concludes only that Mexico has not adequately pleaded its theory of the case, that as a factual matter, the defendant gun manufacturers committed criminal aiding and abetting. Justice Thomas wants the court to state what would constitute a violation of 7903-5A3. There's just one problem with that. It's the role of the legislature to modify the law, not the courts. Remember, the legislative branch writes the law. The judicial decides cases and controversies based on the law. This is another example of judicial activism, this time by one of the most conservative justices. And while Justice Thomas may be wrong about the who, I think he has a point regarding the what. It seems to me that the PLCAA at least arguably requires not only a plausible allegation that a defendant has committed a predicate violation, but also an earlier finding of guilt or liability in an adjudication regarding the violation. Allowing plaintiffs to proffer mere allegations of a predicate violation would force many defendants in the PLCAA litigation to litigate their criminal guilt in a civil proceedings, without the full panoply of protections that we otherwise afford to criminal defendants. Particularly given the PLCAA's aim of protecting gun manufacturers from litigation, see 7901, this issue warrants careful consideration. I agree with Justice Thomas on the point. Could Sig Sauer or Glock be found liable for a crime they have not even been charged with, much less been found guilty of? What about their right to confront the witnesses against them and compel witnesses in their favor?